wherein Mr. Powell made certain statements about my representation of him in the case in the motion for new trial, which I believe created a conflict. And as such, I filed an instant motion in order to abide by the rules of professional conduct when there is a conflict between the attorney and client that renders that representation problematic. Filed the motion, sent a copy to Mr. Powell, and filed the motion with the Court of Appeals. As you know, this case is for the Court of Criminal Appeals, so I filed that motion there as well. They have issued a stay in the resolution of the motion here for your honor.
All right. This is Mr. Stover's motion to withdraw based upon what he believes to be a conflict, an ethical conflict that has arisen. And although the motion for their trial has been resolved in this court, the Court of Criminal Appeals has remanded this case back to me, for me to hear the motion for a new trial. I'm sorry, motion to withdraw, and to try to make sure that the transcript is properly prepared. Of course, the problem that presents itself, had you been retained to actually handle the appeal?
Yes, sir.
And by doing, by filing this motion, it just means that Mr. Powell is going to either have to hire another attorney, or then someone's going to have to be appointed to represent him on appeal. And that creates an issue for me. Mr. Powell, what do you say about this situation?
I have no idea. I don't know.
Well, is there some reason that you're dissatisfied with Mr. Stover's representation of you on the appeal?
Oh yeah. I stated that when in my motion, the affidavit of truth, I stated what I believe wasn't proper for me. It wasn't what me and Mr. Stover agreed upon. There was no time for us to really come up with I never got to understand why certain things didn't happen. It was just kind of just rushed on through. Once you come and sit in these seats, you don't get a chance to speak for yourself. So when me and my lawyer discussed something, I expected it to be done. If we agreed on something to be done in the courtroom, and when it wasn't done, I got no explanation for it. And I just felt I was rushed on through the whole process.
Well, do you understand that Mr. Stover is saying that you, basically by saying that you don't think he ethically or effectively represented you at the motion for new trial, that he doesn't feel that he can ethically represent you on the appeal?
I understand that.
And then if I allow him to withdraw, then you're without an attorney. And so the question is, are you able to hire another attorney to represent you? I know you or your family retained Mr. Stover. And Mr. Stover, are you in a position to, I don't know what the fee arrangements were, but if you're withdrawing and not handling the appeal, are you able to refund any portion of that fee to Mr. Powell's family so that he can retain another attorney?
Your Honor, I wasn't fully retained. I had a partial pay. And so I discussed that with his father. I would make a payment that's owed me an additional money. So there's so I'm not in a position to refund any money, but I'm not charged with the full fee either. So I have not fully been.
I don't understand that neither. You was paid in full for the first for the motion for new trial. You was retained $5,000 for this next part. You haven't done anything. We haven't sat down. We haven't met. So I don't see why you couldn't return another $5,000. Refund that. You haven't done anything to anything. It was just a retainer, right?
You're telling this is not a point where you two get to argue about the money situation. What I'm suggesting to you is, number one, you got to have an attorney represent you on this appeal.
As far as that, Your Honor, I'm not sure where I go from here. Like, I've been abandoned this whole process, so I'm not sure what needs to happen right now. I don't know what to do. So if I can get time, I don't know the process. I don't know what's going on. If I can get time to come up with an attorney, or I'll be appointing one, then come up with one. I'm not sure. I'm going on record saying I don't know right now. I have no idea.
Public defender has even on the appellate process, your office would have a conflict in representing Mr. Powell on appeal, correct?
So,
Mr. Stover, I understand your position, and my concern is that having, according to Mr. Powell, you were paid to represent him on the appeal. If I release you from representing him further, then I've got to appoint someone else who starts fresh in a case that they know nothing about. You've been involved in it for quite some time, so I'm going to deny your motion to withdraw based on the fact that it seems to me that Mr. Powell has got to have a lawyer that you are more familiar with it than anyone else would be, and that I could appoint, and that would delay his appeal. And right now, the Court of Criminal Appeals has remanded it to ensure that the transcripts were adequately and timely filed for this case. And if there's an additional time needed, I don't find that there is an ethical basis just because Mr. Powell disagreed with how you handled his motion for new trial. That gives Mr. Powell the time to hire another attorney to substitute if he chooses to. But I think the Court of Criminal Appeals, it would be disinclined to allow you to withdraw in a case simply because he was critical of your handling on the motion for new trial. And as a result of that, we would be starting fresh, having to appoint someone completely unfamiliar with the case. And I would be appointing them to do so at the state expense, at the public expense, whereas you have been at least partially retained and familiar with the case. And as a result of that, I respectfully am going to decline your motion to withdraw. Mr. Powell, you can hire yourself another lawyer if you don't like what Mr. Stover is doing in your case. But right now, you've got to have a lawyer, and I'm not allowing Mr. Stover to withdraw based on the fact that you didn't like the way you handled your motion for new trial. He can handle the appeal and do what needs to be done for that. But if you don't like that, then you can hire another lawyer. You understand?
I'm not getting anything done. And now this has happened to you. I don't know how we can have a relationship from going forward. Now, he's definitely not going to try to represent me now.
So who do you want to represent you? The question is,
I have no idea. To be honest, I don't know.
that's the reason I'm not allowing him to withdraw, because I don't know who I would appoint to represent you that could. If I appoint someone, another attorney, the public defender can't do it because they represented one of the party or had a conflict. So if I appoint another attorney and allow him to withdraw, then you are starting fresh with a pending appeal and the time constraints that are required for an appeal. You would have to start fresh from that. That person does not know anything about your trial, doesn't know anything about the case. Pardon me. And as a result, I do not find it would be in your best interest to allow Mr. Stover to withdraw and appoint someone else. Mr. Stover devoted months and filed detailed objections and statements of the evidence in your case, and filed detailed statements about the errors that he alleged were committed in your trial, and went through a laborious process of going through all of the transcripts of this trial. There's no one more familiar with your case right now that can handle your appeal than Mr. Stover. And obviously, if there's a monetary situation between him and your father, he can resolve that with your father. And you can hire someone else if you want to, but I cannot delay the appellate process by allowing him to withdraw and appoint a new person who knows nothing about your case. Does that make sense to you? You two are going to have to resolve whatever the issues are so that you can get this appeal moving forward. Because other than this issue and the transcript, it is out of my hands what happens with the appellate process. The Court of Criminal Appeals will handle everything from this point forward. So, Mr. Stover, I understand your situation. I think I've stated the grounds why I don't feel that I can allow you to withdraw at this point, and would ask that you continue in the case and make sure that your transcripts are filed timely. And then if he wants to hire someone else and his family does, then that's fine with me, and I'm sure it would be with the Court of Criminal Appeals, but there needs to be a substitution of counsel. I just don't have another attorney that I can appoint that would not inordinately delay the appellate process in this case.
Yes, sir, I understand. I just wanted to make sure I filed it, make sure I do what I.
You did exactly what you're required to do, and I appreciate your forthrightness, but about, and Mr. Powell, you understand, what I'm doing is what I think I have to do to try to preserve your right of appeal, to make sure that it's not dismissed because you haven't done something. Mr. Stover can make sure that those transcripts are done correctly, and then you and he can talk about this appeal and what's being raised. But I'm going to deny his motion to withdraw and order that he ensure that the Court of Criminal Appeals opinion regarding the transcripts be complied with.
Okay. And you want me to draft that order? And
Yes, please. Yes. Yes, and I just want to make sure that the order reflects that I don't find that there is an ethical basis for that you would be required to withdraw from the case, and that I have no other option to appoint another attorney that would handle this case that knows more about the case than you do, and that for that reason, I don't think it's appropriate to allow you to withdraw.
Thank you.
Thank you.